Welcome to Remedies Video Lecture Series Lecture 2. This is a continuation of contract damages. This session will discuss seller's remedies and liquidated damages. Let's begin with seller's remedies. UCC 2-703 provides that if the buyer is in breach of contract, the seller may resell the goods and recover damages under 2-706, recover damages for non-acceptance or repudiation under 2-708, recover the price of the goods under 2-709, obtain specific performance under 2-716, or recover liquidated damages under 2-718. Remember that remedies under the UCC and as indicated in 2-703 are cumulative and they are not exclusive. That means if a seller cannot qualify for a remedy under one section, other sections of the UCC will provide a remedy to that seller. So let's start taking a look at some of the remedies provided. The first, 2-706, provides that the seller may resell the goods and recover its damages, the difference in the resale and contract price, plus incidental damages less expenses saved. This is a section that permits a seller to mitigate their damages by reselling the goods in the market. This section also provides that if the resale is at a private sale, the seller must give the buyer reasonable notification of the intention to resell. This provides the buyer with the opportunity to choose to buy the goods that the seller is selling and mitigate their damages, or to repudiate the contract and to pay the damages as would be provided under this section or other sections of the UCC. Remember though that notice here in a private sale is a condition precedent or a prerequisite. The seller must provide actual notice of the private resale. If 2-706 is not applicable, then we move on. 2-708 will provide that damages for repudiation or non-acceptance by a buyer equal the difference in the market price at the time and place of tender and the unpaid contract price plus incidental damages. Subsection 2 of 2-708 provides that if subsection 1 is inadequate to put the seller in as good a position as performance, then the measure of damages is profit plus incidental damages. Now let's take a look at a number of situations that occur when the market price and the contract price will not place the seller in as good a position as performance would have. The first of these is when the seller never has the goods, as one case refers to this seller as a jobber. This person merely buys goods from the manufacturer, for instance, and resells them to a buyer. If at the time of the breach of contract by the buyer, the seller does not have the goods, there is no market price that they could obtain for those goods, and therefore the difference in market price and contract price will not place them in the position they would have been in had the buyer performed. The second situation is where the seller has the goods but there is no market. That is, they cannot resell those goods. This is referred to as a component seller. In this instance as well, the difference in market price and contract price will not place them in the same position they would have been in had the buyer performed. The final situation is called a lost volume seller. This is where the seller could have made other sales in addition to the original sale to the buyer. This is where the seller has a sufficient amount of goods to resell and a sufficient amount of buyers to make those resales. And if the first buyer repudiates their contract in this instance and the seller resells, they have lost out on the profit from the first sale as a result. Let's take a look at what the requirements are for a lost volume seller. A lost volume seller must demonstrate that the person who bought the resale goods would have been solicited anyway, that the solicitation would have been successful, and that the seller could have performed the additional contract. Now, going on, 2-709. When the buyer fails to pay the price as it becomes due, the seller may recover, together with incidental damages, the price of the goods accepted or conforming, of goods if the seller is unable after reasonable effort to resell them at a reasonable price. So this catalogues the various damages. As you see played out here, 2703 is the general cataloging section, and it leads to 2-706 if there is a resale. It leads to 2-708 parens 1, the difference between the contract price and the market price, or subsection 2 of 2-708 to the profits, and finally, if the goods cannot be resold, to 2-709 to the price. All of these sections provide, in addition to the damages within them, they provide for incidental damages under 2-710, which we will talk about in a few minutes. Let's take a look at an example. Let's use Sprague versus Sumitomo Forestry at 434 in your book. In this instance, the jury found that there had been a contract for the sale of timber between Sprague and Sumitomo, and that Sumitomo breached that contract before it was fulfilled and completed. The jury also found the contract price of $197,204. They also found that over a period of time, Sprague was able to resell the timber at a price of $144,924. They also found incidental damages equaling $216,498, and these were made up of the following: refinancing, extra transportation, loss of revenue, loss of logging time, and cost of a moving tower. Going on, the court found in this instance that Sprague had resold the timber that was identified in the contract, and therefore discusses first 2-706, which is the difference in the contract price and the resale price plus incidental damages and expenses saved. In this instance, the court found the contract price was $197,204, and you subtract from that the resale price of $144,924, equaling the difference of $52,280. And this, under 2-706, would be the damages. However, and also it would include incidental damages minus expenses saved. However, the court also found that there was not proper notice under 2-706. In Sprague, the plaintiff had resold the timber at a private sale, and the court found that 2-706 required that Sprague give sufficient notice in advance of the resale, and that Sprague had not done this in this instance, and that it was the duty was upon Sprague as a condition precedent to relying on 2-706 for damages to give proper notice. They did not do so. However, as we know, the UCC damages are not exclusive. So the next question to ask would be, does another section apply? In this instance, If not 2-706, then 2-708. 2-708 provides for the difference in the market price at the time and place of tender and the unpaid contract price plus incidental damages minus expenses saved. In this instance, the seller has the burden of proof on the market price as to what is the market price, and the court relied on 2-723 that if market price is not readily available, the price within a reasonable time before or after or at any other place which in commercial judgment or under uses of trade would serve as a reasonable substitute. So the court has some leeway to find what is a reasonable market price in this instance. The court used in this case, it found that the resale after the place and time of tender was reasonable, was within a reasonable time period, and given that prices were fairly stable, the resale price in essence equaled the market price. Therefore, in this case, market and resale price are the same, and the result would be the same under 2-706 and 2-708. Now, Sprague also wanted their incidental damages, and Sumitomo questioned some of the incidental damages that Sprague was seeking. 2-710 provides that incidental damages to an aggrieved seller include any commercially reasonable charges incurred in stopping delivery, in transportation, care and custody of goods after buyer's breach, in connection with return or resale of goods or otherwise resulting from the breach. So, Sumitomo was claiming that some of Sprague's incidental damages were actually consequential damages and not permitted under the UCC. So the court holds, though, in this instance, that incidental damages arise directly from the contract and consequential damages stem from losses incurred by the non-breaching party in its dealing with third parties which are proximately caused by the breach and are foreseeable. That is, incidental damages arise out of the contract in the example of transportation costs, storage costs of the goods, resale cost of the goods, and consequential damages are brought about by third parties who are not directly related to the contract, and we'll see how this plays out in a minute. And in most jurisdictions today, the seller can get incidental damages but not consequential damages. The most recent revision of the UCC now provides for a seller to obtain consequential damages. However, most jurisdictions have not adopted this provision and still limit the seller to only incidental damages. So let's see what the court eventually found. The jury, as we remember, held that incidental damages were equal to $216,498 and were made up of the following: refinancing, extra transportation, loss of revenue, loss of logging time, cost of moving a tower. So now, what did the court hold in this instance? The question that I leave to you is, and that you need to analyze, is why does the court disallow in this case the loss of logging time? What is it about this damage that the court determines is not an incidental damage, but in essence is a consequential damage and therefore not permitted under the UCC? Let's go on. Let's start talking about, for a few minutes here, liquidated damages. Let's talk about them. There's some general principles that will apply and then some tests to determine if they are valid. The first general principle is that liquidated damages removes uncertainty. This is generally the purpose for which they are upheld, that they will remove uncertainty. In essence, liquidated damages are damages that are preset by the parties in the contract. And liquidated damages can be set in the contract as one of a choice of damages or the exclusive damage that will be awarded the parties if there is a breach of contract. Liquidated damages, courts will often say, are not to punish, penalize, or otherwise compel performance. They are not a punishment. If you remember that damages in the contract setting are not to punish the breaching party, but only to compensate and put the non-breaching party in as best a position or close to the position they would have been in had the contract been performed. If the liquidated damage is deemed to be a penalty or to compel performance rather than a reasonable approximation of damages, they will be disallowed. Finally, consistent with the common law policy of allowing for an efficient breach of contract, liquidated damages will be evaluated again on whether they are a penalty or compel performance, or whether they are merely an approximation of what the damages would have been. Let's take a look at various tests that the courts use to determine whether to uphold liquidated damages. There is the traditional test that is set forth in your book in Truck Rent-A-Center. On page 460. At the time of contracting, damages from the breach would be difficult to determine, and the stipulated amount bears a reasonable relationship to potential or actual damages. Now, I've often said that these two sound like there are a contradiction between them, that damages would be difficult to determine, and yet the amount stipulated bears a reasonable relationship to the potential or actual damages. It is up to the parties in drawing up their contract to lay out both of these concerns within the contract and to express them in terms of the liquidated damages that are chosen. And remember, this all is evaluated at the time of contracting. The party challenging the clause, though, has the burden to prove that it is a penalty and therefore is invalid. Liquidated damages under the UCC have a similar test, but it's slightly different. Damages may be liquidated, but only at an amount which is reasonable in light of the anticipated or actual harm caused by the breach, the difficulties of proof of loss, and the inconvenience or non-feasibility of otherwise obtaining an adequate remedy. Again, these are all factors to be considered in evaluating damages at the back end or in preparing a contract to state these damages at the front end. You would have to look at the reasonableness of the amount stated in the contract for the breach, the difficulties that may occur in proving this breach, and finally the inconvenience or non-feasibility of obtaining another adequate remedy. Let's take a look at this concept of efficient breach. I want to do this just for a few minutes before we end here. The contract price equals $55,000. The market price falls to $20,000. In this scenario, the buyer finds a seller who's willing to sell at $15,000. At this point, the buyer breaches the contract. The buyer tells the seller that they are not going to perform the contract, knowing full well that they are going to have to pay the seller $35,000 in damages. That is the contract price minus the market price. The buyer pays the seller the $35,000 just stated above, plus enters into the second contract for the $15,000 on the new contract at a cost to the buyer of $50,000. Under this scenario, the buyer still saves $5,000. The seller gets everything they would have obtained. That is, they get their $35,000 and can now go into the market and resell the goods at the price of $20,000, and this contract is still more efficient. The breach here is more efficient than had the old contract been strictly enforced, or if the old contract had just been adhered to. Another instance that plays out how liquidated damages can affect this. So again, we have the contract price of $55,000, liquidated damage clause now of $30,000, a market falls to $20,000, the buyer fines their seller for $15,000. Damages to the seller now are limited to $30,000. That is all they can get pursuant to the parties. The buyer pays the seller $30,000 plus they pay another $15,000 on the new contract for a total cost of $45,000. In this instance, it's still more efficient for the buyer to breach. However, in this instance, the liquidated damage provision will not fully provide for compensation for the seller. The seller will be out $5,000 pursuant to this, because all they're going to get is their $30,000 liquidated damage, and then can go into the market and sell the goods for $20,000, which will equal $50,000. However, if the original $30,000 estimation is deemed to be valid, this will be the damage. This now concludes this video lecture session. Please do not forget to, upon the conclusion of this, to go to the TWEN site and take the video lecture assessment 2.